I want to share with you today the #1 mistake that people make with their medical malpractice lawsuit, and it's a big one. And it can be summed up having an incomplete set of medical records. So where do you start? You request the medical records, your attorney requests them, and you get records back. The records have a certification that reads, "This is a complete and accurate copy of your medical records." That certification is meaningless. It means nothing. Disregard the certification. Why is this a problem? Because time over time again, with a 90% likelihood the certification will be wrong, you are missing medical records. Why will that backfire? You sue the case based upon a certain number of records, and then you find out that's not everything. There's additional records you didn't have that can ruin your case. That's why having incomplete medical records is the biggest mistake. How do you fix this? Number one, you get the records directly from the hospital or the doctor's office attorney, and you ask them to verify with bait stamp, meaning every page would have a number at the very bottom. Let's say it's 873 records. You want from the hospital or doctor's attorney to verify that those 873 records are complete and there's nothing missing. That is one way of guaranteeing it. In New York, for example, you can serve a legal document that's called a notice to admit. The notice to admit is served on the defense attorney to verify, admit, or deny that the records, the 873 records, are a complete and accurate copy of the originals. Within 20 days, they have to admit or deny. The worst thing that can happen to your case is you go to your deposition or the defendant doctor's deposition, and the defense attorney hands you a stack of records that your attorney has never seen before. That is a nightmare. And then you're confronted with records and you say, wait a minute, I didn't know this. This is all new to me. It gives the defense an excuse for what happened. And then you've wasted a lot of time. You put yourself through stress and anxiety. That's a nightmare that you have to avoid. So the #1 mistake is having an incomplete set of records. The top way of doing that, get the records directly from the hospital's attorney, ask them to verify it, get the records bait stamped so their page numbers are identical to your page numbers. And at the deposition of their expert, you're referencing pages that are the same page. It makes it easier. You know you've got everything. Now, one little extra tip. Not all of the records will come directly from the medical records department. You may need records from radiology department. Those records could include not just reports and imaging, but also requisition slips for the imaging. So there's all these little details. And when you think you have a complete set of medical records, you almost never do. Making sure that your attorney gets a complete set of records is key. Now, one little quick tip. Always request your medical records in electronic format only. There's a federal law called the HITECH Act of 2009 that requires the hospital or the doctor to provide the records to you in the format of your choice. You ask for them in digital because the maximum fee under federal law is $6.50. That could be thousands of records for $6.50. If you do not specify that you want them in electronic format, they will send you physical copies of the records. And at least in New York, they will charge 75 cents per page. So think about it. If there's 5,000 pages of your medical records, 75 cents per page, that's almost $4,000 that you're gonna have to pay just to get your medical records. That is crazy. Many people, many hospitals and doctors don't even know about the HITECH Act of 2009, but you have to be proactive in enforcing your rights and say, no, I only want the records in electronic format. I'm insisting that's my right under federal law. Don't let them get away with anything less. If you like this video, please subscribe to our YouTube channel, like, share the video, and we'll see you next time.